All right, we're live on X. I'm going to go to X here so I can get the link and paste it some other places.
Okay.
As the people can see, we've got the great Professor Richard Epstein with us here, and we will be discussing birthright citizenship in the wake of Trump's executive order. Let me just post this to Facebook, and it's posted. So we're going to get started. My name is Michael Liebowitz. This is the Rational Egoist. And joining us today is the inaugural Laurence A. Tisch Professor of Law at the NYU School of Law, the great Richard Epstein. Professor, welcome back to the show.
It's always nice to be back with you, Michael. Great or not.
So I really want to kind of dive into the meaning of the citizenship requirements of the 14th Amendment. But first, I want to know, what was the context in which this amendment was debated and submitted and ratified?
Well, I think that's the right question to begin with. The context in this case informs the discussion of the text. And it turns out the 14th Amendment was ratified in the summer of 1868, which was a little more than 3 years after the end of the Civil War. It was very clear that there was a lot of worry about exactly what should be done to get the nation rid of the Dred Scott decision, which had taken a very powerful position on the following question: who counts as a citizen? Any person, so long as he's not black. Because the position that was taken by Justice Taney, who was, an extremely gifted and successful both lawyer and Supreme Court judge before this case, is one that basically curdles the blood. And he said, I don't care what it is that a state tries to do, so long as somebody is born an African, it turns out they're not eligible to fitness in the United States as a citizen. They could be freed by their owners. They could always be free. But whatever happened at the state level does not at the federal level qualify you as a citizen. Now, you ask the question, why was he even having to worry about that issue? And there is a head of jurisdiction for the federal courts, known as the diversity jurisdiction, which says this is a lawsuit between two citizens of the United States. And so if you have Dred Scott involved in a case and he's trying to sue for his freedom, and Judge Taney says he's not a citizen, then the lawsuit has to disappear from federal courts. And that's exactly what happened. This was not, shall we say, a small deal. At the time of the decision, it was instantly recognized as a deal breaker for the United States. And there was a large question as to how it should be done. Lincoln spent a lot of time dealing with his inaugural and trying to address this case. And he took the following kind of position: judicial supremacy is a very bad thing when it comes to the articulation of general law. I will accept this particular decision as res judicata in the case, but it has no presidential value or worth as far as I'm concerned. And this, of course, is the exact inverse of the usual understanding of Marbury and Madison of judicial supremacy. It is emphatically the power and the province of this court to declare what the law is, was the famous phrase in rough terms by Chief Justice Marshall. So what we do is we have two American heavies essentially trying to figure out which one is going to be the top dog. And by the time, of course, we get to cases like Brown v. Board of Education, now everybody's in favor of judicial supremacy again because of all the difficulties with segregation. Well, we fight this bloody war, and when it turns out to be over, the question is just, what are we going to do to rid us of the Dred Scott decision? And so that was the primary issue on this thing. And we passed the 14th Amendment, which has many sections, and it's as complicated in many ways as it is short. And so it begins, of course, with the most powerful kind of proposition, which every person born or naturalized in the United States is a citizen of the United States and of the resident of the state in which he resides. So you have both halves of this thing. And the point about this is, if you look at every black person in the United States who had been freed after slavery, they were all born in the United States. They were not even naturalized. And so they become citizens of the United States by virtue of the citizenship clause. And they also become citizens of the state in which they reside. Where the word reside turns out to be actually kind of tricky, because does it mean just living for the moment, or does it mean a permanent domicile? And most people tend to think that the latter meaning, permanent attachment, was what was intended, rather than simply a temporary sojourn, so that you can't reside in any state if it turns out that you just come into the United States for a weekend, stay at a hotel, and then disappear. You're not a resident of the United States because you spent the night at the Waldorf Astoria. Well, that's the way in which the context starts to begin. And then the question is, how far do you take this particular amendment? And the question that you have to ask is, does it apply after the Civil War is over to people who come into the United States and have children in one of two fashions? The first fashion is they enter the United States illegally. And the second fashion is that they enter the United States as sojourners, meaning in effect that they're here for a short period of time with no intention to remain, and therefore cannot be domiciled or meet the residency requirement of the second clause of the 14th Amendment. So that turns out to be what the huge battle is, because when you're dealing with this, you have the question of, hey, these people were born in the United States, right? Are they, in fact, now going to count as citizenship under one of these two circumstances? Well, the easier way to start to think about this is to then ask the first question. What was the status of illegal aliens and sojourners who gave children in the United States before the amendment was passed, right? This is not a question which you can ignore. And you have to look at it in one of two ways. One you can say is, well, we just don't know the answer to that question. But that seems kind of crazy. And so you would then say is, if the situation was that the 14th Amendment changes everything, then the rule would have to have been that prior to that amendment, citizenship depended upon either birth in the United States as a lawful person who's a permanent resident, or having one or both parents who were citizens of the United States, even if it turned out that you were born overseas. The Ted Cruz problem, for example, having a single parent who's American being born overseas. And that seems to have been the general rule worldwide, that those two requirements were there. And so one of the things when you look at, as you see this debate, is how many people actually give you an information and an answer to that question, which is different from the one that I've mentioned. And I'm not aware of any source which essentially states clearly that the sojourner and the alien prior to 1868 had that position. So that's the first point. Second point is the obsession with Dred Scott was, to put it mildly, phenomenal. And you can see why. So the issue you then have to ask is, well, you have this problem about the aliens and so forth. Did they mean to change the basic law of citizenship for people who were aliens or sojourners, that is, people who were not slaves in the United States? And you start looking through the testimony that's been given at the hearing, and you find one or two statements, most of which seem to sort of indicate that this foreign stuff was not on the agenda, or to put it in a more simple-minded fashion, that somehow or other this was a domestic situation. We were not trying here in any way, shape, or form to transform the international arena. And so the system intuition would be, given the context. That's what you asked about, right, Michael? The context would be there's no change unless there's a clear indication of the change, and there's no clear indication of the change from the terms of the statute. So that's the context. What about the text? Should I just keep talking? Is that okay?
Well, I want to ask you a question first.
Good. I thought that would be good since we've gone 10 minutes.
Okay. I'm probably going to butcher the pronunciation of this, but it's a Latin phrase, jus soli. Are you familiar with this?
That
What
means
is
the
it,
right of the source. Yeah,
and
I've
how
already
does it
mentioned.
apply to the 14th Amendment?
Well, what happens is, if you remember, I said there were two ways in which you could acquire citizenship. One was through blood, and the other was through being born in the country. And the question, everybody agrees that jus soli was perfectly generous, and their English and American precedents to do it. The question is not, is there a right of that, but does that right extend to people who are illegally in the country? So to give you an extreme version, suppose what you do is you have somebody who's in jail in your country because you capture them for criminal, and there's a woman who gives birth while she's in jail. Does that person become a citizen? And the kind of situation is, as far as the sort of general legal analysis is, the line between legal and illegal is one of the most important lines in the history of Western civilization. The line between being a killer on the one hand and being an innocent person on the other. So you have both citizenship by blood of parent and citizenship by location. Can you find, prior to 1868, instances of either of those cases where it was a person who was illegal in terms of what they did in the United States, that is, getting here, or a mere sojourner who gets citizenship under the jus soli head? And I'm not aware of any such case. And what's interesting about this is one of the best articles that I've read on this. It takes the opposite position. A very well-known article by now Fifth Circuit Judge James Ho strongly believes, in effect, that these birthright citizen extended in illegal aliens, but that demonstration of a case prior to 1868, where jus soli applied to either the sojourner or to essentially the criminal, is not available. And I'm not aware of any such source. If there were a source and you're trying to figure out what's going on, you would then have to ask the question, how strong? So one of the things that we know about the 14th Amendment, and we know about American law, is a procedural point, which may seem small at the outset, but turns out to be extremely large in the way in which you think about these doctrines. There was a case decided by Chief Justice Story called Swift v. Tyson, in which he had to answer the question, that's a technical question, is somebody gives you a check in payment for some land that you bought, and the land is worthless. And now, if the person who received the check essentially tried to cash it, couldn't do it, right? Because he was a fraudster. But if the check is sold to a third person for fair value, the rule has always been the bona fide purchaser of that check, without knowledge of this, can sue the person who committed the fraud, whose sole remedy is against the person who issued the check. So basically what happens is the innocent purchaser can get the money from the innocent body. And you look at what Justice Story cited, and their international source after international source from both the continent and from England and so forth. And the clear view that he had was this was a matter of sort of general principles of law, not tied to a particular jurisdiction. And that was the applicable rule of how you thought about things in the 1860s. And so it'd be quite natural to look to international law, or to the law of another country, to explicate the phrases. So privileges and immunities, that's not a phrase that comes trippingly off the tongue. And if you're trying to figure out what it is, you go back and examine some of the English charters that talk about that in one form or another. And the same thing would apply, I think, to the question about legality. And there is, in fact, a doctrine decided around 1900 in a famous case called Pocket Habana, which says international law is, in fact, part of the law of the United States unless contradicted by something else. Customary international law was a much more coherent club before 1900 than it is today. And the general rules of international law, I think, did not give you essentially a leg up on citizenship by being a sojourner or by being an illegal alien. So now, against that background, you look at the text, and what does it mean to be subject to the jurisdiction thereof, right? Now, if you just read that text,
That was my
and
next question. You preempted my question. It was about
well,
what does it mean about the jurisdiction?
yeah, I mean, the first thing about it, you look at the darn phrase and you say, I have no idea what that means as a matter of ordinary English. So again, what happens, it has to be historical and contextual. And so what we do is you start going through the cases. And the first case, which everybody agrees is covered by that, is if you're somebody who is a diplomat who represents a foreign nation, you're not, quote, subject to the jurisdiction of the United States, because the phrase means you have exclusive loyalty to a foreign sovereign who has sent you there. And so therefore you're out from underneath this law. And it means that if you are a diplomat or a diplomat's wife and you have a child in the United States, that child is not a citizen. All right, well, is that exhaust the meaning of the phrase? The answer is, how could you possibly tell unless you have some more knowledge about the historical context in which this arises? So the second case to which this admittedly applied, according to just about everybody, was the case of Native Americans, American Indians. The relationship between the Indian nations and the United States is an extraordinarily complicated one. It's built into the constitutional framework. Congress shall have the power to regulate commerce with foreign nations among the several states and with the Indian tribes. And it turns out that whatever's going on with respect to the first two is not quite the same as what's going on with respect to the third element, that is with the Indian tribes. And what they generally concluded is the relationship we have with the Indian tribes is not that we have direct control over them, simply is that they are separate sovereigns and you do business with them. So that what happened is in 1868, it was widely understood that Indian tribes were not subject to this, members of Indian tribes were not subject to this provision, which means what happens next? And what happened next is it stayed like that for a while. And then Congress decided to pass a statute, which said, in effect, members of Indian tribes are now citizens of the United States. And what is clear is you not only can get citizenship by virtue of the first clause of the 14th Amendment, you could also get it by congressional action. There is, of course, no congressional action that has been taken with respect to aliens and with respect to sojourners. Okay, well, then the question is how much further you can go. You start looking at debates at the time of the 14th Amendment. Very little is said about this particular problem, but there's at least one or two quotations from important people to the effect that this also includes aliens. That is, people who come from foreign countries, because they owe their sovereignty to other leaders. And if you think about it, if the Indian tribes who don't have independent sovereignty against the United States, right, because they're half subjected to it and half free of it, well, then somebody who, in fact, is a citizen of France or Germany and so forth, certainly has an independent sovereign to whom he owes loyalty. And so, therefore, when he comes into the United States, he can't get the benefit of the citizenship clause. There's then be said, well, that means you can't do anything with respect to this guy. But that also turns out to be wrong. You have to look at the 14th Amendment and take very carefully the internal structure of Article 1, Section 1. The first thing starts with the citizenship clause, tells you who is citizen, and then the next clause gives you the payoff of what comes by virtue of being a citizen. And it say, no state shall make or enforce any law that abridges the privileges and immunities of the citizens, right, of the United States or the several states. So what citizenship does is it gives you the protection of privileges and immunities. Another phrase which doesn't come easily off the tongue. You have no idea what this thing means if you just read the text, and you have to go back and you have to read Corfield and Correll, a famous American case from the 1820s, which gives an imperfect explication of it, and then start looking again at those English charters, which use that phrase all the time, to give you a sense of how it starts to go. And the bottom line is actually not crazy. It seems as though if you're a citizen of the United States, you can do two things that aliens cannot do. One of them is you can own property, right? And another one is that you can enter into various kinds of occupation. Even citizenship, by the way, in 1868 did not guarantee you the right to vote, right? There's this little pesky issue known as women's suffrage, which did not resolve that question until 1918 or 20, when you had the First Amendment. And so you have to be extremely contextual and assume that many of the biases of the time work themselves into the 14th Amendment. And indeed, when they start talking about, who counts as a citizen, very complicated formula in the 3/5 rule, everything is limited to male citizens of the United States. So down in the Constitution, it's pretty clear that sex discrimination was, before 1971, under an original reading, a permissible distinction to a bunch of people who, of course, had sex differences up and down the line on every conceivable issue that you could measure. Indeed, the movement towards full capacity for females in both civil and public capacities really didn't take shape in the United States until somewhere in the 1870s, but it was not part of the constitutional framework. And this, again, you talked about context, right? A decade makes a huge difference in terms of the way in which people start to think about these things. Just think about it. 1858 was the Lincoln-Douglas debates, right? And 1868 turns out to be the 14th Amendment. Lincoln didn't defend citizenship, right, for slaves in 1858. What he said is you just can't own these poor people, but you don't have to give them the right to vote. By the time he dies and you get the 18th Amendment, those 10 years mark a complete reversal of sentiment in this country in virtue of what happened during the Civil War. And so you have those kinds of advantages that you get as a citizen. And then you have two other clauses dealing with equal protection and with due process. And the operative word there is person, not citizen. And so what does it include? At the very least, all persons include citizens and aliens, right? So you have a constitutional structure that essentially creates a two-tier constitution. The citizens, in effect, can have these occupational freedoms, and they can have these property freedoms. If you're an alien, you're here on suffrage. You can't own, you can rent, and you can only work if Congress decides to give you some kind of a work permit. Right? And those are completely different conceptions. What we do, in effect, is you have robust preferences under the citizenship clause. And then the question you have to ask yourself, are those preferences the kinds of things that you want to give to sojourners and illegal aliens? And the answer, it kind of almost speaks for itself, no. What happens is those people come in and they get some very important protection. If they own property, you can't confiscate it. And if you are about and free on the streets, they can't just throw you in jail, right? And the rules have to be the same for criminal procedure, equal protection of the laws for citizens and aliens, and the rules with respect to the protection of property against seizures also have to be the same. So it's a two-pronged structure. And one of the things that's quite clear when you read most of the modern account is that the difference drops out. There was a famous case called the Slaughterhouse Cases, decided in 1872. And this was a particular case which mangled the Privileges and Immunities Clause. Nobody thought that the only privileges and immunities that counted under this clause were the ability to petition government and to sail on a navigable river. You do not run the most contentious and impassioned debate over a constitutional amendment that has that utter insignificance. But when the Supreme Court decided this by 5-4, what happened is it turned out that the majority of the court believed it was very dangerous for the United States government to be a perpetual censor of everything that went on in the states, right? And that's what happens when you talk about making enforced laws. So they backed off from that. And in the middle of that opinion, without any citation to any authority whatsoever, what they then concluded is you go back and you read the discussions, and by God, subject to the jurisdiction of the United States does not include aliens as sojourners. No citations given. It was a kind of a contemporaneous notion. We regard certain truths that are today vigorously converted as being self-evident. And I think that the stronger evidence suggests that they caught the mood even if they didn't document the decision. So if you're trying to figure out what's going on in an amendment, having a contemporary interpretation of it is generally a plus. Having a sloppy and incomplete interpretation of it reduces the size of the plus, but I don't think it reduces the sign. So all things considered, looking at this, it turns out that birthright citizens for illegals and for sojourners does not seem to be part of it. Now, take them separately, and it turns out there are kind of nuances that are worth talking about. As I mentioned earlier, you have to be a citizen of the state in which you reside. Nobody believes that the alien who comes in order to give birth to her children gives them birthright citizenship if you take that second clause seriously. But many people, when they actually cite the 14th Amendment, they just drop off the second clause and they end up only with the United States. But it makes absolutely no sense whatsoever to treat these people as residents when no matter where you look, under whatever doctrine in any country in the world that you care to mention, will you find the sojourner being regarded as a resident. And if they can't become residents, then they're probably not covered by the clause in either half. Well, then you take it one step further. If you're not going to allow a person who's legally in the United States under these short-term conditions to give citizenship to their children, are you going to allow somebody who comes in illegally to do the same thing in the face of an interpretive reading of that funny phrase, subject to the jurisdiction thereof, and a general international law history that says nobody's allowed to profit from their own wrong? Are you going to say that illegal aliens get this particular benefit? And I think, from what I've said before, the correct answer to this is they can't do it either under the narrow textual situation or the larger contextual issues based upon references to international and to English system. Is this clear, Michael?
It is, but I do have some questions.
Well,
one concerns the debates over ratification of the 14th Amendment, where one senator, and I can't remember all their names, the only ones I remember are Jacob Howard and John Bingham, and then, of course, Trumbull. But one guy raises the objection to the 14th Amendment and says, but this is going to make the children of Chinese immigrants who aren't citizens, they're going to be citizens. The senator from California agrees with the sentiment and then says, but that's a good thing that they're going to be citizens. And nobody objected to the idea that the children of Chinese immigrants were going to be citizens.
Yeah.
And there's also that the word subject to jurisdiction, the word jurisdiction at the time, as it was understood, meant just subject to the laws. I'm not giving the exact definition. I don't remember.
Well, I mean, that's disputed. That is if your interpretation is that, then if it only diplomatic immunity is subject to the laws, then citizenship should have been given automatically to Indians. But it took legislation to do that. Well, now, let me go back to the first thing. Okay. What you said, in fact, was correct but incomplete. If you go back and you look at what happened, there's a famous case called Wang Sung Ark, a 1898 case, where exactly this issue was raised. And the question was, did you, when you had that debate, talk about the problem of illegality, or did you only talk about the problem of Chinese who are lawfully admitted into the United States? And so you have to look at Wang Sung Ark to get some kind of an answer to that question. And what happens is you can scan the entire opinion, and the word illegality or illegal entry into the United States is not there at all. That is, they're not talking about that. In fact, before you quote the generalized language of the opinion, it is important to remember that in its introductory passage, what the court goes out of its way to do is to say that the parents in this case came over very early on. They were lawful in the United States. They were basically given all kinds of protection, but under something which you would regard, I think, today as probably unconstitutional. Since they were Chinese, they were not eligible to become citizens. And so if you're trying to figure out what the ethics of the time was, it was pretty clear you could make some rather blatant distinctions between Chinese and everybody else. And it's really one of the things that's important to understand is that 10 years before we had all of the debates over this issue, what we did, the debates over this issue, is we had the China exclusion cases. And you want to find the most racist language in the American Supreme Court since Dred Scott. That's it. That was the way in which they talked about this. And so what they're doing is they're saying this guy is absolutely terrific. He's a wonderful person. And then what they said is since he was parents were lawfully in the United States. When he goes overseas, we can't shut the door and keep him from coming back in again because the children of lawful aliens in the United States are in fact citizens of the United States. And this is a rule that applied not only to Chinese, but it applied to everybody else. And the novel feature about the Chinese, and they did the right thing, is they applied it even though they were not eligible for citizenship under the applicable law, which drew these very strong racial and national origin distinctions, okay? So then what you do is you start reading the opinion, and it's done in very, very broad language, and it refers to all the precedents that I've mentioned. But what it never does is to see either it or any of the precedents that it cites use the phrase to cover legality, illegal behavior, as well as legal behavior. So you can't use that statement to answer the question, are Chinese eligible to come in under the 14th Amendment? The answer is yes. Are illegal aliens who are Chinese or illegal anything else doing it? There's no affirmative evidence that supports that particular proposition. And so when you get away from the Chinese context and you start having aliens from all other places in the world, the applicable rule is if you are somebody whom we admit, one of the ways to establish citizenship and to basically strengthen your ties, since you're here lawfully, is to give citizenships to your children. And there's nobody who wants to do that. Now, let me just mention one other thing, which I think is kind of important, is how do you want to apply this change? And first of all, if you agree, as that judge said, that this is an absurd argument that I've just made, right? That I'm functionally illiterate. Well, then you just simply send the case away. But there was no analysis in that case whatsoever. It was a short order, abusive in tone, and utterly devoid of analysis. But the one thing is, I'm a very strong believer in the protection of the reliance interest. So I would think it would be a total abomination to say, look, we've operated under this rule, which has no constitutional foundation, and that all of the acts done under that particular rule are now void because the rule was wrong. And so everybody else who's a son of a legal alien, you may have been here for 25 years, you're gone. The rule should only be supplied prospectively. And that's generally the way in which major changes ought to be applied when a situation is recognized that the earlier decisions were wrong. You do not want to basically create senseless hardship for anybody who's been here. But going forward, all the incentives say you do not want to encourage birthright journals to the United States, and you don't want to encourage illegal aliens coming into the United States by giving them this particular possibility. And so, as a generalized matter, the birthright citizenship is a mistake for illegal aliens and for sojourners, and you could rectify it going stronger and also protect the reliance interests of people who are already here.
Okay, I want to back up a little bit.
Sure.
Well, actually, quite a bit, because you've already taken us up to the current executive order and the decision that was just rendered. You've mentioned quite a few times that there were no cases prior to 68 of illegal aliens having children that were deemed citizens. You also mentioned how in Wong they didn't address illegality. But there's a very strong reason for that, and that's prior to 1868, there were not general federal restrictions on immigration, so you wouldn't have had this abundance of illegal immigrants that had this problem. And if you even back up to the beginning of the country, previously you and I had a discussion about the constitutionality of immigration restrictions at the federal level, and you used your principle of constitutional interpretation that you just invoked to say, well, once it's established, it becomes precedent and it's okay. But under an original meaning interpretation, there's nothing in the original document that grants the federal government authority over immigration. So there wouldn't then be these cases.
Sure, there would
1868. Well, how?
Sure, there would be, because what happens is you have somebody who's entered into the United States illegally, and he wants to sue somebody saying, I'm a citizen of the United States. And the answer is, since you came illegally, you can't bring this lawsuit. The whole principle of Dred Scott rests on exactly that kind of proposition.
Well, he wouldn't be a citizen, right?
But no, but I mean, you just have anybody who's an alien who comes in illegally. There's nobody who's blocking the entry, right? By the way, and what it means to be an illegal alien before that time is not clear, but suppose it turns out that you have somebody who is regarded as a criminal and he's told expressly not to come in and he comes in anyhow. What would happen is this would be done collaterally. But the point is, other countries, of course, had restrictions on immigration, and they also followed, I think, this kind of a general rule. Now, I actually wrote one kind of interesting subject on the paper on this about the power of immigration, having to do with the situation at the border. It's very clear if you look as an originalist, right? There's no federal power over immigration. It's all naturalization, not immigration.
Right.
And it turns out that's just not a sustainable situation because that means immigration from any one state coupled with movement across states by anybody in one state legally means that you have a national problem in which the most poorest state dictates the situation with respect to the country. And if you go back to the 1880s, okay, and the same period we're talking about, and this problem comes up with the Chinese exclusion, what do you see? The Supreme Court saying, hey, immigration authorities are in power of the sovereign. Is that the state sovereign or the federal sovereign? They don't say, but it's the federal government. So it's so much of American constitutional law. You have a very flawed initial doctrine, and then you core it by ipsa dixit. So what I said to myself is, how does this then relate to the situation at the border? And I think what happens is the federal government essentially gets the first crack at enforcing the laws to keep everybody else out under decisions which were dubious originally, but have been basically incorporated into what I call the prescriptive constitution.
Prescriptive, that's your doctrine. I always forget what you call it. Every
Yeah,
time I forget.
but it really works, by the way. I mean, and half the Constitution is prescriptive, including stuff on citizenship. No corporation is a citizen. Oh, yes, they are. They are now citizens of the state in which they do the principal phase of business and where they incorporate. Does that mean they can vote? Well, I mean, you can see our Constitution becomes jerry-built because the original institutions were completely flawed. The same thing is true with respect to the Electoral College. And the whole thing got ballsed up in so many different ways. It didn't work as a deliberative body. And so what you did is you had a bunch of decisions which say you're just messengers. You don't even need the people. You just send in the votes. You send the people there, and then you get the 2020 crisis. It's a very flawed document, and sometimes prescription works. So what I said is if the federal government enforces it, the states cannot override it by letting people in. But now the Greg Abbott situation was the opposite. You had the federal government letting people in, not only letting them in, you've seen the footage, Michael,
Yes.
of people being helped across the border by border agents knowing they're illegal, right? Well, in that case, can the federal government be told, you have basically abdicated your duty and we are entitled to fill the gap because you've done nothing? And I actually think it's a pretty strong argument. I mean, if this is a delegated power to the federal government and it completely fails to do something about it, then the parties, i.e. the states that did the delegation, should be able to pick up where they should have done. And so this means, in effect, that you can't trump, pardon the word, federal policy if the government doesn't do the kind of job that you would like it to do, so long as they're trying. But it means if they throw over the gates, you can't do it. There's a case called Hines and Davidovich from the 1941 or 2, which gives the federal government absolute power over immigration, a recognized that, on aliens during wartime, right? Remember, the wartime distinction between an alien and a citizen is a big deal, right? So why does it disappear everywhere else? And where do they get the immigration power? It's sure bluster. One of the things that we know is the great features of the American Constitution are, in fact, deeply flawed. And it just simply doesn't make any sense.
Okay. I've got a couple more questions for you. One is one of the arguments, because I do think the 14th Amendment provides for birthright citizenship, but one of the arguments I hear that's meant to sort of circumvent the jurisdiction argument is to say, well, it's true that they're subject to jurisdiction if you're born in this country, but if you're part of an invading army or an invasion, then you're not subject to jurisdiction. So they tag immigrants as invaders. Do you think that argument has any weight?
Did you hear me make it?
No, I did not hear you make it, but
Well,
I'm
I
going
mean, my view is an invasion, when you're talking about this, is typically an organized force coming into the United States, not random stuff. And in fact, there's a kind of a peculiar reversal here. Invasion is the kind of thing that provokes the ability of the federal government to come out. And this definition of invasion is too broad, just as the definition of an insurrection that was used against Trump was too broad. These were a set of uncoordinated, in some cases, criminal trespasses, which should be treated as such when everything went to pieces, right? But it doesn't follow that it was an insurrection, even if it turns out that it was a riot. And so, I mean, you have to be very careful about the use of your terms. One of the interesting features is just at this time, 1900, right? We won the Spanish-American War. And now you have the problems of what are you supposed to do when you conquer somebody? And we had two situations, simplify. There was a situation in Puerto Rico where essentially there was a civil government and we basically had an orderly transfer of power. And then we had the situation in the Philippines where there was an ongoing insurrection. A bunch of guys in the hills armed with weapons trying to take over the government, right? And what McKinley did when he was president is he issued an order to the Secretary of War, Elihu Root, saying, you put this stuff down before we do anything else. And he did. And then he said afterwards, there's this guy named William Howard Taft. He was a Sixth Circuit judge. I'm now making him the commissioner of the Philippines. And he's supposed to put into place a civic code to make sure that the place actually runs. And he was an amazing man in the way in which he did it. A truly extraordinary performance. And the price that he pays today is he's now routinely branded as a racist because he used the word alien to describe aliens. We're under a very sensible, very tense situation. And I have no desire whatsoever to make weak cases on this stuff. What I do is I have a desire to sort of put all this stuff together. And I think on balance, the case against is stronger than the case for. I will write this up in some greater form. I'm not so sure that the government made all the arguments that I would make, but they certainly made many of them, and I don't think they made any blunder. But even if you're right, I mean, when I read that opinion, I said, this judge has never heard me talk about this. Why is he basically calling something absurd? Particularly wasn't had done a single bit of hard work about it. And so the dogmatism is what bothers me. Anyhow, I mean, I think we kind of covered the waterfront.
We did. I just have one more question about
You may always ask it.
executive orders.
Yes.
As you said earlier, the Constitution provides for the federal government. Congress has power over naturalization.
Mm-hmm.
So even if it's granted that the 14th Amendment does not cover children of illegal aliens, children born here, wouldn't it be Congress's job to step in, given the precedent that's already here, given that that's the law we've been going by? Wouldn't it be Congress's job and not the president's job?
I could not agree with you more. Joe Biden was absolutely abusive in his misuse of executive orders, and Donald Trump is now following suit. So to give you but one illustration, what do we think about TikTok, right? It's a kind of an interesting, hard case in which there were a lot of courts that reviewed this stuff, including some very sensible judges who said, we don't care what kids are gabbing with one another. It's the ability of the Chinese government to collect information, to use it to propagandize, and to engage in sabotage what bothers us. We order the divestment. Where does Donald Trump get the authority to suspend for 75 days?
He has none.
He has none.
No.
And so what happens is we now have executive order disease. Both administrations pushing much too hard on this. And as a basic rule of thumb, if there's something that has to be done and a major change, it has to be done by legislation. And the usual purpose of executive orders is to fill in the gaps. And the moment you send somebody like Joe Biden say, I'm going to give you an executive order that will govern things in 2035, the first answer is no president has the power to dictate the state of the affairs after he's out of office. And the next guy can remove it. But we don't even want to have this situation where people do illegal acts under which there are short-term consequences, and then hope the next guy will remove it or keep it, and then you have other short-term consequences. So we have a real epidemic of lawlessness in this country. It started very modestly about 25 years ago. And in fact, by the time you get to Obama, it starts up, and then you get Trump and Biden. It's a bad, bad situation. So the rule of law requires you do that, but it also requires you recommend the following maxim: extirpe causa non oritur actio, which means out of an illegal cause, you do not create a viable cause of action. And therefore, you cannot rely on a doctrine of birthright citizen to cover illegal aliens or sojourners. Okay?
Professor, your mind is razor sharp. I look forward to reading whatever you write up on the subject. Thank you so
Okay.
much for joining us here today, Professor.
Okay. Will you send me a copy of the link when you're done?
It's not going to go up yet. I've got to get this to my producer first, and once I get that, I will get you the link right away.
Thank you so much.
Thank you so much. You have a great night, Professor.
You too.
And thanks everybody for joining us.
Bye-bye.
Take care. Fucking sweet.